Welcome, everyone. And so since it's 1 o'clock, I'm going to get started. I have opened my chat box, so if at any time you have a question, you can type it in there and I will try to answer it. I just wanted to start with, if someone could type and let me know that y'all can hear me and you can see the screen, that would be great. Okay. All right. Thank you, John. I appreciate that. So I am at home today on this lovely spring day with 2 inches of snow, and hopefully spring is around the corner soon. I'm going to be talking today about, obviously, debunking common estate planning and probate myths. My name is Steiner Peck, and I've been an attorney for over 25 years practicing in this area, estate planning and probate and trust administration for all that time. So this is an area that I enjoy talking about because in estate planning and probate, it really is a very personal area where I have the opportunity to help families. So to me, it's very personal, and I enjoy being able to help people during this difficult time and try to make at least one thing at that time a little easier. So that's me. And I started with 6 common myths about estate planning and probate that I'm going to go through. I may pop in another 1 or 2, though, just as I go. But one of the things that I've found, and I think this is hopefully becoming a little less commonly thought by people, is that when we hear the word estate, a lot of times we think, oh, a large estate, somebody who's really wealthy has an estate. And sometimes we think, well, we don't have an estate, so we don't need to do any type of estate planning. And a lot of times, for purposes of estate tax planning, or it's also referred to as death tax planning, nowadays that can be the case, that from a tax standpoint, a lot of people don't have to worry about it anymore, because this year the estate tax exemption is at over $12 million per person, or that would be about $24 million per couple. So in the old days, when we were thinking about estate planning, even people who didn't have enormous estates had to think about estate taxes. When I first started working in this area, the estate tax exemption was only $600,000. So even though nowadays we don't need to worry as much about the estate tax portion of estate planning, everybody has an estate of some sort. And estate planning is not only something that the rich need to worry about. Estate planning encompasses many areas. As I put, who inherits your property? So even if I don't have a large estate, I still want to be in control of who is going to inherit my property. Because if I don't plan my estate, then the state of Ohio has a plan for me. It's called Intestate Succession. So what the word intestate means is without a will. And so if I die without a will and my assets go through probate, then they're going to go according to statute. If I want control, then I'm planning my estate. And so even if I don't have $12 million, I still want to make sure that the people or charities that I want to leave money to inherits that money. And so it involves estate planning. In addition, part of estate planning is not just what happens when I die, but also what happens if I'm alive? Who handles my money for me? You know, a lot of times when I'm planning with clients, one of the things I talk to them about is that even if they can't take a step forward in planning who inherits their estate, it's so important to decide who helps you if you're incapacitated. So let's say that I have a stroke and I become unable to handle my finances and I haven't done any estate planning. Then what's going to happen is that, again, the state of Ohio is going to help you out. And maybe someone will file in the county probate court to become my guardian. And then all of my finances will be run through that guardianship and reported to the court. It becomes much more complicated to do that, as there's going to be a lot of court filings and the guardian's going to have to ask the court's permission to pay expenses. So when we're thinking estate planning, we shouldn't just think taxes. We shouldn't just think wealthy. We should think, who takes care of me if I'm incapacitated? And that's not just for finances, but also for purposes of health decisions. So let's say that we have a married couple and they don't share similar views on making medical decisions. If married couple does not have estate planning and there's a guardianship, if the spouse takes control of the guardianship, then he or she will be making those medical decisions as guardian. Or let's say that that's not the issue, but you have 3 children and you want one in particular making those medical decisions. It's not because you don't like the other 2 kids, but maybe that person has more time to make those decisions and you see more eye to eye on medical care with that particular child. So when we're doing estate planning, you, through a document called a healthcare power of attorney, can decide who you want making those medical decisions for you. And to back up a little, when we're planning in estate planning, the who handles your finances, if we're going to take control of it and not just have it happen through a guardianship, then that document is called a financial power of attorney. Sometimes it's referred to as a durable financial power of attorney. And so those 2 documents say, I'm taking control of who's going to take care of me if I become incapacitated. And finally, a big part of estate planning involves, sometimes who handles the funds if I have a disabled child, a young child who's going to inherit. And it doesn't have to be a child. It can be, a niece, a nephew, someone you care about that you're leaving funds to. And the person doesn't have to be disabled or young. Sometimes we have beneficiaries who simply can't handle funds for themselves. Maybe they're a spendthrift. Maybe they have drug or alcohol problems. So part of estate planning involves thinking about not just who's inheriting my money, but how are they inheriting my money? So there's a lot that goes into estate planning other than just saying, I'm so wealthy, I have this large estate that I'm planning. I also want to touch on the fact that estate planning, when we're thinking about it, can also include planning for our long-term care. The cost of nursing homes nowadays, the average, is, my understanding in Ohio, is about $6,500 a month. What I normally see is more like 8, 9, 10, 11, even $12,000 per month. So part of estate planning can be planning to properly pay for that care, preserving assets for a spouse, etc. And so when I was thinking about estate planning, it brought to mind this show that I watched the other day. It was a Marie Kondo show. So I was thinking, boy, kind of estate planning is kind of Marie Kondoing your estate to make sure that it's neat, it's in order, and you're in control of it. So I'm going to flip to the next common myth that I hear people say. They tell me, well, I have a will, so I'm not going to go through probate. And a will actually is designed to go through probate. But I'm going to back up because I realize that not everyone understands what probate is, when it occurs, and what it's meant to accomplish. And so, sorry about that. So the idea of probate is it's an organized passing of assets through the probate court. And so I think a really simple way of thinking of it is like this. If I have a bank account and I pass away and it has no beneficiaries on it, then that asset is going to go through probate. It's going to go through the court. It will go to my beneficiaries under my will, or if I don't have a will, it will go through intestate succession. If I have a bank account that has a beneficiary, it's not going to go through probate. And so the idea is that assets that don't have beneficiaries, are not in trust, are not held jointly with somebody, are assets that will go through probate and pass in accordance with your will. So having a will tells who's going to inherit, but that in and of itself does not avoid probate. And sometimes people decide they want to avoid probate because it can be more time consuming. In order to properly administer a probate estate, there are filings that have to be done with the probate court so that a person can be officially appointed as the executor or administrator if there's no will, and carry out their duties of paying bills, making sure the final 1040s are filed, gathering up the assets, making sure that there's no creditor issues hanging around, and finally dividing up the assets and filing an accounting with the court. So these different filings are public record, and anyone can go down to the courthouses and take a look at this. More courts are becoming more private, I see, but some courts still have filings online. So you can actually say, oh, I know that, Bill Smith passed away. I wonder what kind of money he had. And if it's online, you can actually look that up, look at the inventory of Bill Smith, which lists all of his probate assets, and look at his death certificate, look at all sorts of information, look at the accounting that's filed and see what kind of bills were paid and who inherited. And so, this is one of the ways, because of the fact that it's a public record, that you sometimes see celebrities who die and go through probate, why suddenly all these journalists know everything about their estate. So the other reason that people sometimes want to avoid probate is that most people, well, I shouldn't say most people, a lot of people use attorneys to assist them through this process so that the documents are properly prepared and filed timely. And so there's legal fees obviously associated with that help that an attorney provides. And the person serving as executor is entitled to executor fees as well. And so the idea is that, sometimes if we feel when we're evaluating what to do with an estate that we'd like to avoid probates, these are sometimes the issues that we're trying to avoid. But simply having a will in and of itself is not going to avoid probate. Okay. Over the last 20 years, I have found that, using a trust, a lot of times it's referred to as a living trust. It's also considered a revocable trust. Sometimes spouses have joint trusts, but this document is used to avoid probate. And a lot of people think, well, the only way that I can avoid probate is to use a trust. And that's not true. As we were previously talking about, the assets that go through probate, through the court, are assets that do not have a beneficiary, are not joint and survivor, do not, aren't using a transfer on death account or affidavit for real estate. So there are many ways to avoid probate without a trust. So I've listed some there. Joint and survivor assets. I'm sure a lot of you have these. So if I went to the bank, for example, with my spouse, and I said to the banker, I'd like this account to be joint and survivor, what that means is that during life, my spouse and I both own the money in that account. And at death, it goes to the surviving spouse with no probate. That can also be utilized with non-spouses. And so that's going to, avoid probate without the use of a trust. Quite a while ago now, the transfer on death affidavit was created under Ohio law, and I've seen many other states have this as well. And what it is used for is real estate, because it allows us to avoid probate on real property without going through probate, but without giving any ownership interest to the people I name as beneficiary. So, for example, in the olden days, so to speak, when I first began practicing, if someone had a piece of property, piece of real estate, their home, and they wanted to leave it to their child, and for whatever reason didn't want to use a trust, they might use a joint and survivorship deed. So the positive of that at the time was that it was simple, inexpensive, but the negative was that meant that my child, who I put on as joint and survivorship owner, had an immediate ownership in the property. And so if I had a falling out with my child, then this could become problematic. If my child became divorced, there could be a problem with that. And if my child had creditor problems, there could be an issue with that. So it certainly wasn't the preferred method of avoiding probate with real estate. Instead, we have now the ability to use a transfer on death affidavit. So if I own my house, I can name my children as the transfer on death beneficiaries. This avoids probate, and it can be simple, and it is inexpensive to do. And it definitely is an easy transition at death. So some people feel that the transfer on death affidavit, while it avoids probate and the probate court, may end up in another court. And the reason for that is because we have to consider when we're planning, because we want this to be a plan. When we're estate planning, we don't want it to just be, I heard that so-and-so said this was a good idea to use a transfer on death affidavit, I'm doing it. Because let's say I have 2 children and I want to leave my house to my 2 children, but they don't get along. When I die, we're like, hooray, we avoided probate and it was so simple. All I did was file a affidavit of confirmation and now the house is theirs. That's one result. And if my children get along and love each other and are both financially on equal footing, that can work out great. But sometimes that doesn't occur. Maybe they don't get along and one wants to make sure that they pay the real estate taxes and fix up the property by both contributing money. And the other one's like, no, I don't have any cash to do that. Or maybe one of them ends up getting divorced. And in Ohio, we still have what's called a dower right. So now we have to get the divorcing spouse to sign off if we're selling the property. Sometimes, child A might say, hey, my son is just getting started in the world. He needs a place to live. Why don't we let him live there rent free? That's what mom would have wanted. And so as you see, there can be many issues, even in the best of families situations, when real estate is left to children together. And so the idea is, I always tell people when they're considering a transfer on death affidavit, that we need to take off the rose-colored glasses and say, and what's going to happen at your death? Will the children get along? Will the beneficiaries get along? And so the idea is that utilizing that type of a probate avoidance technique can be a positive, and I do have families where it works out well, and it can be a negative. And so it's definitely not a one size fits all. We shouldn't just focus on one part of estate planning, which is, hey, I'd like to avoid probate. We need to look at the pros and cons of the approaches. We can also use for other assets beneficiary designations. So just like with the transfer on death, beneficiary designations for assets don't pass to your beneficiaries until death. So that means you can change them if circumstances change. And also that anything that happens to your beneficiary while you're alive won't affect your assets. So that's a positive. If I am using a beneficiary of my IRA and it's my children and one files bankruptcy, it doesn't affect the IRA for me. And so beneficiary designations on accounts can avoid probate without using a trust. And then we have giving away assets before you die. For some people, this makes sense, but we always want to think about the tax considerations in doing this. Sometimes people give away those assets not just to avoid probate, but also for long-term care planning. And that needs to be considered very carefully because of the effects both on Medicaid, if I need it in the future to pay for nursing home care, and also income tax issues such as what is the basis in the property. And so while we can avoid probate in many different ways without using a trust, we need to evaluate our particular situation and our particular beneficiaries, because as you all know, no two kids are alike, no spousal relationship is exactly the same. So we want to look at our estate planning options and decide what works best for our family or other loved ones or charities that we're including in our estate plan. So I'm going to go through this very quickly because I talked about this a little bit on the prior slide, but this is one of the ideas that we always want to make sure we know what's going to happen before we do something. So we don't want to say, well, my friend Susie did this, so I'm going to do it because it worked out well for her family. So we always want to make sure that we know the pros and cons in estate planning, probably in everything that we do in life. But here, we always want to remember that real estate is very different than cash and stocks, etc. We can divide those assets pretty easily, but major issues with real estate, whether I'm putting my house joint and survivor with my child, or if I'm leaving it transfer on death to multiple children, is that you need all of these things. You need to recognize that it's owned by the beneficiaries, that you can't sell without everybody who owns it approval. And if they're married, the spouses as well. We also may have issues with what are the tax results of this, and recognize that if there's any creditor problems, that the house can be seized, because I can't divide my house into equal parts for my children in my transfer on death affidavit. I can't say child 1 gets my garage, child 2 gets the basement, and child 3 gets the rest of the house. So this is a more difficult asset, obviously, to deal with than cash, etc. And it takes that planning. I'd like to expand this next slide into a will decides who inherits my IRA, to also include bank accounts, annuities, real estate, etc. Because a lot of times I have people say, well, my will goes to Bill and Susie, and then they have a bunch of different beneficiary designations on all of their assets. And so maybe they have taken their bank accounts and they've named Susie as the sole beneficiary because she's in town and she can help me pay my bills. Or they have also said, I've named Susie as beneficiary of pretty much everything, and that way she'll be the one who can pay the bills and almost act like an executor without the probate court, and then she'll dole out the money. And so, and she has to, because it says that she has to split it in the will. And this is simply not the case. The will is only going to control probate assets, those assets that don't have a beneficiary. So the idea is that if I have a bank account that passes to Susie, then Susie is the sole owner of that account at my death. She doesn't have to use it to pay for my funeral. She doesn't have to use it to pay my final bills. She doesn't have to share it with her brother Bill. In fact, because unless he can say that I made a mistake, that I was incompetent when I named Susie as my beneficiary, then Bill really doesn't have a leg to stand on. It's Susie's money. Will Susie do the right thing and share these assets? And sometimes I see Susie do the right thing, and sometimes they don't. There's a lot of people who can justify a lot of things to themselves, such as, well, I was the one in town to help mom all these years, so I think she really meant for me to, get that extra money, and I'll decide what Bill gets. But another issue that comes up if Susie is trying to do the right thing is that it may have an impact for her in her estate plan. So the idea is that if Susie inherits all of my estate And she says, I'm going to do the right thing. I'm going to pay all of mom's bills with these assets. I'm going to file her 1040. I'm going to pay any income taxes that are due. And then I'm going to divide it with Bill. Well, now we have to look at Susie's estate, because that means she's making a gift to Bill. And every year we can make $16,000 gifts to individuals. It used to be 10 and it's been ratcheted up without filing a gift tax return. But if she is giving him $50,000, now she has to file a gift tax return. And if she has a taxable estate, she may be using up some of her exemption. But in addition, maybe that's not an issue, because again, back to our initial slide, if most people aren't paying death taxes because the exemption's at $12,060,000, then it may be that now we have to make sure Susie does it quickly, because what if something happens to Susie? Susie inherits my estate, and then Susie becomes incompetent. Now we're not relying on Susie to do the right thing. We're actually taking funds away from Susie. And if she has a guardianship, maybe the court doesn't allow that. Maybe if she has to go on Medicaid, that becomes an issue. But the whole idea is that when we're thinking about beneficiary designations, when we're thinking about avoiding probate or going through probate, when we're thinking about using a trust, the idea is that the word plan is right in there. So what I try very hard to emphasize to people when we're planning their estate is we don't want to rely on Susie's goodwill and health and tax situation. If we want something to go equally, then that's how the plan should be, whether it's going through probate, using a trust, or using beneficiary designations. So the idea is that we want to make sure that these documents achieve our goals. So in our planning, we're thinking about, do we have tax issues to consider? Who takes care of me if I'm ill? And what are my ultimate goals in someone inheriting my property? And then we look at, what are my tools that I have to get that property to them? So we know now that a will doesn't cover non-probate assets. And I have lots and lots of people tell me that all the time. It doesn't matter. I have a will, it won't go through probate, they'll inherit, and it just doesn't always happen. And also that I have to have a trust in order to avoid probate. And just having a will avoids probate. But I have a question. Is the right thing for Susie to do become the POA on the checking account and make the estate or all siblings the equal beneficiaries? What a great question. So the idea is that a lot of times that is what I encourage people to do, to say, if my goal with my checking account is really to have Susie be able to have access and pay my bills, it doesn't have to be joint and survivor. She can simply be on as power of attorney. And then I want to consider the options, either having it go through probate, having it payable to a trust, or having it payable to my beneficiaries. And paying to a trust or to other beneficiaries would avoid probate. Having just Susie with no beneficiaries would have it pass through probate under my will. And so the only thing that I can't say in answering the question, John, is, without exploring goals, is exactly which way makes the most sense. But yes, definitely, I like Susie being on as power of attorney. So we're not disrupting what you really want to accomplish in leaving assets. So that's a great question. Sometimes using a joint account, if it's just a very small account that money comes into and out of, and that's, joint with Susie isn't going to create a big disruption in your estate plan, that can work. But the power of attorney can be very powerful to allow the access without the inheritance. So I'm going to, okay. So the next slide is just, thinking of a one size fits all kind of plan. And that is, well, okay, Jennifer said that probate can be expensive and it's public record. So I don't like that. I am just going to fill out a bunch of beneficiary forms for my bank account, my IRAs, my real estate. It's just cheap and simple. It's true. It's cheap and simple. But we want to make sure it's also planned. So some of the things that we just want to think about is when we're avoiding probate and we're just simply filling out beneficiary forms on accounts, it doesn't always work out the right way for every family. So we want to look at our family and what we're trying to accomplish. So we have issues such as, what happens if one child dies prior to you and you want their children to inherit their share? So for example, a lot of wills and trusts are drafted so that if I'm leaving my assets to Bill and Susie, they go what's called per stirpes, a Latin term meaning by the root, meaning that my estate will be split into two shares, regardless of whether Susie and Bill both survive. And so let's say in this scenario that Bill predeceases me and my estate is going to go in two shares under my will. One share goes to Susie because she survived. And if my will says that Bill's children inherit his share if he predeceases, then his children share his half. And that will, happen. Most wills take that into account. Most trusts take that into account, but not all beneficiary designations are going to take that into account. So let's say that I have a transfer on death affidavit and I have, again, Bill and Susie as my children, and I name them as beneficiaries. And Bill predeceases me, leaving two minor children. If I haven't put their name on it, we cannot use just the language per stirpes on a transfer on death affidavit. I have to use real human beings' names. And we don't really want minors owning real property with another adult. So now we have two minors, one adult sharing property. So this can be kind of difficult. Going through a probate or using a trust can be easier to for that particular situation, because if my will says that the executor is going to sell the property and it's going per stirpes, then I have an adult, my executor, handling the sale of the real property and then turning over the cash from that to Bill's children using a custodial account or guardianship, etc. Or if I have a trust, again, I can have the trustee sell the real property, divide it into shares, and hold it for those young beneficiaries. And so while it can be easy to fill out forms and it's inexpensive, it doesn't address that situation all the time of what happens if a child predeceases. Some beneficiary designations do and some don't. But I also touched on the second item, and that is, what if one beneficiary is just too young to handle the funds? So let's say I want to leave $50,000 to my grandson. I think he's had a hard time and he needs this additional assistance. But right now he's 15 and I don't know when I'm going to die. So the idea is that if I'm just naming him as a beneficiary on my account, then I might end up with a guardianship that has to be administered. If instead I think about using custodial accounts or a trust agreement, I can provide more management of those funds until he becomes a much older age. So we already talked about the multiple children and real estate, and that can be handled oftentimes better, depending on the situation, in actually going through probate and having the executor sell the real estate and then just passing out the money, or with using a trust where the trustee is selling the real property and passing out the money. We do have, though, also the issue that I brought up at the beginning, and that was that I have to think about who my beneficiaries are. So obviously, in the best of situations, we want our children to have a perfect life. We want nothing bad to ever happen to them. My two children are right now in college, and, I worry about them all the time. And I hope and pray that nothing bad ever happens to them. But life is messy. And if my child that I want to inherit has creditor problems, drug issues, alcohol abuse issues, maybe they're just not good at handling money. Some people aren't. We all know those people who, if they know they're going to get paid $100, have already spent $200. I have those people in my family. So not everybody is good with money. Sometimes people get divorced. And so when we're thinking estate planning, we don't want to focus on just the how do I avoid probate? How do I make it as cheap as possible, etc. We want to think about who is inheriting, how they're inheriting. Do I need to set up some sort of provisions in a trust for my child or other beneficiaries so that the funds can be handled for them, so that if they do have these creditor issues, the trust can provide some insulation, or if they do get divorced, the trust can provide insulation of those assets, or even that I can put somebody else in charge of the money so that it's not all blown in one fell swoop. That maybe I provide that my child gets $2,000 a month until the money all runs out, so that at least I know, there's something there for them and it's not going to be spent all at once. So it can be very important to consider the who of who is inheriting when we're doing the plan. And one of the other issues that I have on there is who pays the last expenses. When I have all beneficiary designations and I don't have a probate and I don't have a trust, no one's in charge. There's no estate to be in charge of. There's no executor appointed if I don't have a probate estate. So even though you have a will that says I appoint Susie as my executor, Susie's not executor unless the court appoints her as executor. You're nominating her as executor. So Susie's not in charge. No one's in charge, so to speak. And, again, it all depends on the family, but sometimes there can be issues with this. One child ends up paying the entire funeral expense and goes to the other child and says, hey, could you chip in? And the other child's like, I can't. And there's really no recourse there, because if there's no estate there's no probate estate, there's no trust estate that is holding these funds for these final expenses, they really don't have to. And I hate to say that in some families, one person does end up paying for everything, and doesn't get the input from the other family members, unfortunately. And so we want to think about all of these things when we're planning our estate. So, okay. I do want to add just kind of a wrap up though, before I take questions, and that is that, this is an important area for all of us, regardless of our estate. Not everybody has a one size fits all, of course. Some people are going to need more planning than others, depending on their assets, their goals, what they're trying to accomplish, and their relationship with their family, their loved ones. Maybe it's a second marriage situation. So everybody has their own particular issues to consider in determining what is the right course for them. But I'm hoping that at least these, 6 common myths that I feel are out there, you understand how they actually work now. There's one final area that my firm practices a lot in, that we have to consider with our beneficiaries. And that is, I talked about beneficiaries having marital problems, creditor problems, drug or alcohol issues. But also if we have a beneficiary with special needs, that is receiving any type of public aid, then we have to be really careful as to how they inherit. And usually we're going to have to consider something like a special needs type of trust so that we can provide the inheritance without disqualifying them for public benefits. So for example, let's say that I have a child who has schizophrenia and they're unable to work and they're collecting Social Security, maybe they're collecting SSDI, maybe they're collecting SSI, maybe they're collecting food stamps or on Medicaid to pay for their medical care. If I die and I just say, here's $100,000. I hope it helps better your life. What's going to unfortunately happen is if any of the programs that they're on, such as Medicaid or SSI, are needs, and food stamps are needs-based, saying how much money you're allowed to have before you can be on these programs, then the inheritance is going to knock them off the programs. And so unfortunately, it's not going to better their lives. It's just going to be used up and then they'll go back on the programs. But the government allows for the use of special needs trusts so that instead of me just putting Susie on as pay on death beneficiary of my accounts, I can leave the accounts to her in special needs trust instead, and they can be used to help better her life so that she still qualifies for the programs. But in addition to those, base amounts that she's given, she might be able to do things such as buy a computer with the funds from the special needs trust, or have a companion so that maybe she's lonely and doesn't have any friends due to her illness, be able to have travel, to have a little bit of spending money. So the idea is that, once again, when we're taking into account our plan, we're thinking about the who as to who is inheriting and what we might want to plan for them, and not just about things such as avoiding probate or using pay on death accounts. So it's important to think about the whole person when we're doing this plan. So at that, I hope this all made sense to everybody and it was helpful in thinking about your own plan. And if anyone has any questions, you're welcome to type them into the chat box and I will try to answer. Okay, so it looks like we have a question. Just a thank you. Thank you. I appreciate you all joining me today. And I hope that you will also consider coming to other talks. I do see another question. So what assets transferred to children incur an income tax consequence for the children? And are there ways to avoid this for the children? Sure, that is a great question. So annuities and IRAs are income taxable. And so when I leave annuities and IRAs to a child, I should be aware of the income tax consequences. The IRS just came out with some proposed regulations on the new rules of inheriting IRAs that I'm currently working my way through. But we have to be careful when we use a trust, especially with these types of assets. Other income tax consequences can be if I give money away during my life, such as when I am doing Medicaid planning, for example. If I have my house and after making sure that it made sense to do, I decide to gift it to my children, what will happen is that they will have my basis in the house. And what that means is if they turn around and sell it, they're going to pay a capital gains tax that is the difference between the basis I had, and that's usually what I bought it for and additions and things like that, versus what they sell it for. So a simple example is if I bought a house for $50,000 and I give it to my children, not on death, but during life, I give it to my children and they sell it for $100,000, they're going to pay a capital gain on $50,000. So it's that kind of income tax consequences that we always need to think about when we're considering gifting. And also when we're considering how to leave assets to children. Let's see, looks like there's two other questions. Is there a trust that would encompass more than one thing for someone who is married and has children? For example, spendthrift clause for the kids that also covers long-term care for the spouses and real estate. Yes, and so we can accomplish different things within the same trust. We want to be thinking about, how we're accomplishing that and what the current Medicaid rules are. But yes, we can often combine what we're trying to accomplish. For example, if I have a child that I decide I want to get some spendthrift protection and I have a special needs child that I'm leaving assets to, I also could use the same document and have it address both of those things. Is a living trust the same as a revocable trust? How often can you change it, or should you? Living trust is the same as a revocable trust. It can also be called an inter vivos trust. And I think that you should review it at least every 3 years, or if something substantial changes in your life. But sometimes you can be once and done, and for other times it doesn't work out that way. Maybe the tax law changes affect you, something that happens with your children affect you, or maybe a trustee that you nominated has died. And so I think if you're looking at it every 3 years to see if it needs to be updated, maybe it does, maybe it doesn't, but it also can bring about that peace of mind. So then we have, with the Persterpes going to my children, does it go to their grandchildren? Yes. And so let's, I just want to break that down just a little bit. So let's say that my will says that my assets go to my children equally per Persterpes. Then one of my children predeceases me. his share will go to his children under my will. So anything that goes through probate and goes through the will is going to go to my grandchildren that were my son's children. However, what we want to remember is that that's if he predeceases me. If I have a will and assets that go through probate and I say it goes equally to my children per stirpes, and both of my children survive me, and then one of them dies, it's going to pass according to their estate. So my estate is no longer going to affect it unless it was held in an ongoing trust for them. And so sometimes if I say to myself, I want it to go to my grandchildren after my children are done with it, that can be another reason why people sometimes want to use a trust so that it's held for their children's lifetimes. And to the extent they don't use it, you're controlling where it goes next, not your children's estate. And then the question is the gifting amount you mentioned per child or per year? It's per person per year. So the idea is that I could use that what's called the annual exclusion amount to as many people as I wanted. So let's just say I wanted to leave 100 people a gift, and I wanted to do it every year. I could. And so this annual exclusion is going to be something that I and my spouse each have. And it's $16,000 this year. So that means I could give $16,000 to Bill, $16,000 to Sally, $16,000 to Bill's spouse, $16,000 to Sally's spouse as well, and to all of my grandchildren. So, and then the next year I can do it again. Thank you for speaking slowly, not a common trait for lawyers. No problem. Thank you. How do you transfer assets into a trust? Simply list them there. That is a great question. That can be done for certain tangible property, but the idea is that usually what you want to do is actually change the title. So for example, if I want a bank account in trust, then I would go to the bank and have a new bank account set up in the name of the trustee of the trust. And during my lifetime, if it's my trust that I've set up and it's revocable, then it's going to use my social security number. So sorry, folks, you still have to pay income on whatever income is earned on that account. And Barbara asks, how much does it cost to make a trust? Do you have to pay to review or make changes? And so, you know, everybody's different. And so it really depends, Barbara, on what's being accomplished. I do have clients who, believe it or not, have over $12 million. And so we're going to have a much more complicated plan. But sometimes I have people who have millions of dollars who have a very simple plan. And so it depends on what the plan is. As I said, there's no one size fits all, but I think a pretty common range that I see, not only just for our firm, but also for other, firms that are similar to ours, are going to be about $2,500 to $5,000, kind of in that range. And so that's why I always do a pros and cons of what we're doing, because I like to be cognizant of making sure that what we're doing makes sense financially. And then there are other documents that may come into play as well, a will, powers of attorney, etc. But I think that's kind of a common range. And again, it depends on what you're doing, though. Great questions. Okay. I think I'm just looking to see if there's any more questions. Okay. Well, thank you all so much. I can't wait till we can see each other in person instead, because I feel like it's easier to interact that way. But I do appreciate your spending part of your Saturday with me. Um, my partner, Lori Steiner, is going to be talking about Medicaid, and my partner, Mike Solomon, will be talking in a couple weeks, and he may be touching on some of the new IRA rules, which are very interesting, complicated, interesting, etc. But I do appreciate you're all attending and look forward to seeing you soon. Take care.